welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here today with our attorneys Clayton Calvin and Eric Hyges, and our director of litigation, Chance Weldon. We are bringing you Supreme Court cases as they drop this session, and today we're here to talk about, well, what seems to be some speech cases. One we're not going to talk a whole lot about speech on, and one we're going to talk a lot about speech on. Fair warning, we're going to talk about Afroman. So if you are Afromaned out...
Not a Supreme Court case.
Not a Supreme Court case.
Important.
We're going to veer from our beaten path a little bit today to talk about the Afroman case, or Cooley v. Foreman if you're a technical person. But before we get there, let's talk about our Supreme Court case that actually dropped this week. Olivier v. City of Brandon. So Mr. Olivier is a street preacher. He was preaching outside an amphitheater, and the chief of police of the city of Brandon comes up to him and says, hey, there's a city ordinance that says you can't preach here outside the amphitheater, but we've got a designated protest zone set up out there. You can go to your designated protest zone. A free speech zone. Go protest in your free speech zone. And Mr. Olivier goes to his free speech zone, looks around and says, I don't like this. So he goes right back to where he was before and meets again the chief of police, who says, okay, now you're under arrest for violating our city ordinance. And Mr. Olivier then pleads guilty to violating the city ordinance. He's slapped with about a $300 fine and a year of probation. While he's on that probation, though, he decides, I want to do this again. I want to continue both as an expression of my religious liberty and also because this is my free speech right. I want to go back to this amphitheater and continue preaching. So he files a 1983 action, which is a civil rights action against the city seeking prospective relief. Now, initially, I think he was seeking damages, but quickly abandoned his claim for damages against the city and said, I'm just looking to not be arrested again under this ordinance. And that's why we're here talking about free speech, right, Chance?
And well, also, he paid the fine. I think you said this, but he paid the fine. He didn't serve any time.
Yes, he didn't serve any time, but the city immediately says, nope, you can't sue over this because of a case called Heck v. Humphrey. Now, Heck v. Humphrey is not a free speech case. Heck v. Humphrey is a 1983 case that was brought by an individual who was sitting in a jail cell, wanted to get out from his jail cell, was seeking damages against the prosecutor in his case, and filed a similar 1983 action. And in Heck, which was also a Supreme Court case, the court held that 1983 could not sustain a suit that would necessarily imply the invalidity of a prior conviction.
And for listeners who might not know, when you say 1983, you're talking about Section 1983 of the Civil Rights Act of, I think, 1868, which allows people to sue the government when their rights have been violated.
Right, specifically to sue states if their rights have been violated under the Constitution. So Heck held that a criminal cannot use 1983 to bring a claim against the state challenging the invalidity or the constitutionality of the statute that they're then convicted under.
Well, of a prior conviction.
Yes, yes. So if you've been convicted of it, you can't turn around and say that it was unconstitutional under 1983. At least in very broad terms, that's the argument that the city made. Mr. Olivier said, no, this is not going to apply to me because in Heck, this was a man who was in custody and he was trying to get damages. I'm not trying to get damages. I'm trying to get just don't arrest me again. And also, this is not something that I'm trying to undo. I'm not trying to get my conviction reversed. I pled guilty to this and I'm okay with that. So when Mr. Olivier brings this suit, it ends up going all the way up to the Supreme Court on the question of, does Heck bar this particular kind of lawsuit? And the court in Olivier that just came out this last week held that Heck only prohibits the use of 1983 to challenge the validity of a prior conviction or sentence so as to obtain release from custody or monetary damages. So in other words, yes, the Heck bar still lives.
Yeah, not overruled.
Not overruled. But then they held, assuming a credible threat of prosecution, a plaintiff may bring a Section 1983 action to challenge a local law as violating the Constitution and to prevent that law's future enforcement. So in other words, yes, Mr. Olivier, you do still have a live case, but this heck bar does still live. So this is kind of an odd set of circumstances, and I'm just going to kind of start here. Chance, you're a public interest lawyer. We're all public interest lawyers, but you've been doing this a long time. Are you generally suing the government because of past things that the government has done, or are you generally suing trying to stop the government from doing things in the future?
Most of the time we're suing to stop the government from doing something in the future. And I think that's one of the reasons that this is such a cool case and an important case, is so much of what we do. When you start this job, you think, I'm going to be suing over the First Amendment, or I'm going to be suing over the Second Amendment. And then 90% of what you're suing over is, how do I get in court to actually get the court to, adjudicate the merits of that constitutional claim? Because the government is always trying to find a way to say, you can't sue us. You can't sue us yet, or it's too late for you to sue us. And so, most of the time what you're trying to do is, before you've been arrested, before you've been prosecuted, you come in and you say, I want a declaration or an injunction to stop this law from being enforced against me because I think it's unconstitutional, and I shouldn't have to bet the farm or go to jail or wait till I've been prosecuted in order to have my rights protected. And so that's normally how we litigate these cases. But this was a little bit different here.
How is this one different, and does it make a difference that he's not sitting in custody when this arises?
So there's a little bit of an irony here in the way that this has been argued. So much of what we do whenever we sue the government before you've been prosecuted, before you've bet the farm, so to speak, what the government does most of the time is they come into court and say, well, you can't sue us yet because we haven't prosecuted you. It's not ripe yet. Who knows if we'll prosecute you in the future? You have to wait until you've been prosecuted. And here, in this case, the person had been prosecuted. He had been prosecuted and convicted in the past, and he wanted to get relief in the future. And there the government says, now it's too late. Now it's too late. Before you didn't know you'd be prosecuted. Now it's too late. And so, this is about what that magic sweet spot would be, where the government was essentially arguing that the case wasn't ripe until it's moot. Mm-hmm.
So, Eric, you and I have talked about this on a number of occasions, and this has arisen in a couple of cases that you and I have worked on together. This assuming credible threat of prosecution. Is that something that when the courts look at credible threat, they're very statistical, like, yes, this is credible, no, this isn't credible, or is there a lot of gray area there? And do we always see that there's a credible threat of prosecution when a prosecution has already occurred?
Yeah, it's one of the tools that the government likes to use to get rid of cases, especially pre-enforcement challenges where you're seeking prospective relief against an unconstitutional statute. Part of the standing analysis is whether you've been injured, and if you haven't been prosecuted yet, the argument goes that you don't have an injury unless there is a credible threat of prosecution. And what courts are really should be concerned about here is this a really old or obscure law that is never enforced? Maybe it's something that was enacted when the criminal code was first enacted in the late 18 or early 1900s, and it's not something that the government is actively going after people for. Or it could be a case where a law is very broadly worded and it's not clear whether that law actually applies to the conduct that you are saying you have a constitutional right to do. So that's the areas, the core of the credible threat of prosecution analysis. But the court has explained this standard in a very broad sense. And so the government is very incentivized to say, oh, well, there's no credible threat of prosecution. We've never threatened to prosecute against you specifically. And so therefore, there's no credible threat of prosecution. There have even been cases where the government will put out press releases heralding this new law that they're going to go after people for violating. And then when someone sues to prospectively join the law, then the government says, oh, well, we have no intent to actually enforce it.
We were never going to do that. Why would we do that?
And so it's frustrating as a public interest litigator when, on the one hand, you have a law that is on the books, a prosecutor could file charges against you tomorrow for doing it, and yet they say that there's no credible threat of prosecution.
And I think, too, we've even seen cases where somebody has been prosecuted for an offense. I think immigration attorneys or immigration enforcement, this has been an issue where someone has been prosecuted and has sued to stop that prosecution from happening again. And the court has said, yeah, but what are the chances? But what are the chances that you're going to get arrested for this again? So there's no credible threat of this particular violation occurring a second time. So it's a hard hoop to jump through. But here we finally, for once, met it. Mm-hmm. Again, the court is just assuming. They say we're assuming a credible threat of prosecution against Mr. Olivier. But Mr. Olivier is saying, yes, I'm absolutely going to go out and do this again. Is his declaration that he's going to go out and violate that statute enough?
Well, it depends on how he's...
Case,
go ahead, Eric.
Yeah, in the ordinary case, it is. You have what the courts have said is that to show a credible threat of prosecution, you not only have to show that it has been enforced in the past, but also that you have a concrete intention to violate the law in the future. Essentially, that the law prescribes activity that has a constitutional interest.
So, in other words, if this law is drawing boundaries around a constitutional thing that I'm allowed to do, and I say I'm going to go ahead and do that thing, that should be enough to get me to standing? Chance is nodding.
I mean, it should.
It should. How often is it?
I mean, most of the time. I mean, there's some really good precedent, for example, like in the Fifth Circuit that says if you're the object of the regulation, this is a case called Contender Farms, that you don't have to violate the law in order to challenge it. That if you've declared an intent to engage in the activity that's arguably prescribed under the law, then that's sufficient for standing. As a matter of fact, and this is talked about in the opinion we're talking about today, years ago in a case called Woolley versus Maynard, the facts looked almost identical to the facts here. There you had someone who had previously covered part of their license plate. They had covered the live free or die on their license plate. They had been arrested and charged with that. And then they wanted to get an injunction so they could, not be arrested or charged in the future. And that declaration that they intended to engage in this arguably constitutionally protected activity was sufficient for them to have standing. We ordinarily don't require them to actually violate the law before coming to court. And so ideally under the law in the good cases, yes, that doesn't mean that you're not going to face the argument every single time that you file a lawsuit.
In your experience in all of the cases that you filed, have you ever had a case where the government has just conceded standing on a pre-enforcement challenge?
No. I don't think we've ever had one where they've conceded.
Interesting.
Where they've just said, yeah, we acknowledge you were the object of the regulation and so therefore...
I take that back. Our FinCEN case, they did acknowledge that it did apply to us.
But it's more like they sort of they omit it, or they look over it, and if the issue of standing isn't like raised or flagged for them, then they just kind of assume it. But they're not like, oh, we acknowledge that you have standing under Contender Farms. Like if the argument's raised, they're going to say that we don't have standing. They're going to try to attack, plaintiffs for procedural things rather than get to the merits.
But in this case, we're just kind of assuming that you have standing under this credible threat of enforcement standard. You're still not going to get to make this challenge, this 1983 challenge, under Heck v. Humphrey if you are sitting in custody or if you are seeking some sort of damages, right? Mm-hmm. It's only this claim for prospective relief. Mm-hmm. This case really comes down to the fact that the court's trusting Olivier when he says, I'm not trying to undo my prior conviction. When he says, I'm not trying to get an expunction here. I'm calling this into question, sure, by nature of the fact that I'm saying that I was convicted under an unconstitutional statute. Mm-hmm. But I'm not trying to undo my conviction here. How often does a court normally listen to that kind of promise?
I don't think it's not so much that whether they listen to it. It's just, actually, a simple answer would be to say never. They never take it at face value, what the plaintiff is saying. But what courts do instead is they look beyond it and look at the actual substance of the claim and say, is this guy in effect trying to upset a past conviction and change the outcome of that conviction itself? Or is he is he trying to get relief from and be able to exercise his rights prospectively instead? And that's where the court drew a line just by looking at the substance itself.
I think that's kind of goes back to what Heck was really about. And we haven't had really a chance to talk about it yet, but the reasoning behind Heck was that typically if you've been convicted of a crime and you're in jail and you want to challenge that, prior conviction, the mechanism available is something called habeas. And habeas is guaranteed under the Constitution, and there are statutes that deal with habeas where you challenge a prior conviction. And there are other statutory mechanisms that exist for challenging a prior conviction. And what the court said in Heck is you can't circumvent that traditional process by applying 1983, which is typically, used for civil damages or civil injunctive relief. And so what the court's done here is said, okay, but that doesn't mean that once you're outside of the context of challenging that prior conviction or trying to get out of jail, that 1983 claims are forever barred. And so that's really what all this case did. It said, look, Heck was about preventing people that are in jail from circumventing the habeas process, trying to do an end run with 1983. It shouldn't be read so broadly that it gobbles up when people want to use 1983 for what 1983 was intended for, which is forward-looking relief or relief against a new violation that has nothing to do with your prior conviction, just because, the claims might affect the vibes of your prior conviction.
But the court's still going to look at what you're actually trying to do in the lawsuit. And so even if you have a claim for prospective injunctive relief with the bundle of all your claims, they're going to look to, like, does your declaratory relief, your damages claims, do those in the bundle also, like, are they going to have the effect of upsetting a past conviction? And if so, then we won't listen to it.
And it's probably worth kind of diving into a little bit what the different kinds of relief are that people are seeking, particularly under 1983, and how those are different from habeas. So what are the different kinds of relief? Eric, I'll toss this one to you. What are the different kinds of relief that are available under 1983, and how are those different from the kinds of relief that you'd be seeking in like a habeas or an expunction kind of hearing?
Sure. So the two main forms of relief for Section 1983 are money damages, which are retrospective. The government violated your rights, and so you want to be monetarily compensated for the harms that deprivation of rights caused. And then the second one is for prospective relief, which is what we're talking about in the Olivier case, where you can get an injunction from the court that says this law is unconstitutional and government, you may not enforce it in the future. But in habeas, we are only looking for release of the terms of confinement. So habeas challenges a person who is in jail for an unconstitutional reason. Something about their conviction violated the Constitution, and the remedy there is getting out of jail because they are unconstitutionally being held. So it's a powerful remedy, but it's also very limited. You have to be in custody, and you also are limited as far as how many times you can file for habeas by a law called the Anti-Terrorism and Effective Death Penalty Act that limits the federal habeas remedy. So it's a powerful tool, but it's also a limited tool.
And just as a practical matter, too, the habeas is complicated. Habeas is a very intensive process. Something like 60% of all habeas petitions are kicked on technicalities. So, like, habeas is hard. If that's how you're going to seek your relief, that is difficult. And so it makes sense that somebody who's sitting in a jail cell would want to go a different route to get relief, especially in like a 1983 action, which is relatively simple relative to the process and procedures of a habeas. Why isn't habeas available? Sorry, go ahead.
Yeah, especially if you want to get money damages. Money damages are not available under habeas. So your only way to get money damages for the government violating your constitutional rights is through a Section 1983 action.
And a habeas is technically a collateral attack on a criminal conviction, whereas a 1983 under Heck is not. You cannot collaterally attack. You can't come at it from the side and say my conviction is unjust. So it's fundamentally different from a habeas. Here we've got a footnote saying that Mr. Olivier, for purposes of our opinion, Mr. Olivier was never in custody. There's a note that he was on probation when this whole thing started, but by the time this gets up to the court, and for whatever reason the city didn't raise the status of him being in custody, so the court just says, he's not in custody for purposes of this analysis. So he couldn't bring a habeas claim because there's no body to deliver. He can't be brought in front of this court. So if he can't bring a habeas and he can't bring a 1983 action, what remedy would he have had if this case went the other way?
I mean, the government's argument was none. And it's just too bad.
Yeah. Well, he pled guilty.
Yeah.
Yeah, it sucks to be you.
Res judicata, you can't go back and undo that.
Yeah. And so I think
it was
there's
interesting
something
at the very beginning of the government's case. The government the lawyer for the Mississippi government said there are all of these different ways that he could have sought relief at the time. One of them was going through the appellate process in Mississippi. He also mentioned that Mississippi courts have a process to get rid of or review this conviction. They also talked about pardons and expungements, but ultimately those, especially the last two, are more discretionary. And a lot of litigants want to be in federal court because it provides a much more powerful remedy against violations of the Constitution by states.
So Mr. Heck is not in custody for purposes of this discussion. Do you think it would have gone any differently, Eric, if he had been in custody?
I think yes, especially if he were in custody in the traditional sense, like he was sitting in a prison cell, it would have gone a lot differently, because the whole reason why Heck was decided was because the court wanted to avoid a conflict between Section 1983 and the habeas process. So they wanted to make sure that if a case really should have been brought under habeas, that it is channeled to that path. I think you would also have a problem. We were talking earlier about credible threat of prosecution. The government may also try to say there is no credible threat of prosecution while you're sitting in a jail cell. So, for example, in this case, the ordinance banned street preaching, essentially. And so you can't street preach if you're in a prison cell. So what the government may try to argue is that if you're in a prison cell, there's no credible threat of prosecution until you get out. I think it's a much more difficult question if the person is out on probation, which the Supreme Court has said for habeas purposes, probation or parole or that sort of a situation is still custody. So you can still collaterally attack your conditions of quote unquote custody, your probation or your parole through the habeas process. And so it would be a different situation where someone was able to walk out on the streets and was able to street protest, but they were still under conditions of custody for federal habeas purposes. I think it'd be a much more difficult case.
So, Chance, the language of 1983 doesn't include any procedural bars identified by Heck, right? There is no Heck bar in the language of 1983. They don't talk about parallel litigation. None of this. You can't collaterally attack a conviction. None of that is in 1983. Was the Heck Court acting within its authority when it declined to follow the text of the statute and read this bar into the statute?
So it's hard for me to defend extra textual limitations on 1983, which we can talk about on another episode. But I think what they were doing here is applying this older sort of canon of construction, where if there's a specific right available and a general right available, that you follow the specific right first, that you direct to the specific remedy that's available that Congress created, rather than reading a broader remedy to cover the same activity. And when you're talking about someone who is incarcerated, the remedy there that's provided is habeas. And so it's this implied sort of order of operations. That's the strongest argument for Heck, is whenever you have these mechanisms available that are specifically designed for incarcerated people to challenge the terms of their conviction, we're going to force them to use that remedy as opposed to, finding some other statute to do an end run and collaterally attack that. And so that's the best defense for what the court did in Heck. But what had happened over the years is that clever government lawyers had started to use that as a way to bar people from bringing claims when they weren't in prison, when they weren't trying to overturn a previous conviction, when they were simply trying to get prospective relief going forward for something that they had been convicted of in the past, right? And so that's what this case fixed. It fixed that problem.
So you mentioned this, we have habeas to get us out of that 1983 problem that's been created here. But what about damages? What if I'm sitting in a prison cell and I do truly believe that I was convicted of an unconstitutional statute? Maybe I didn't know it on my direct appeal. I didn't bring it on my direct appeal for whatever reason. I can't get damages through habeas.
Yeah.
What's the rationale for saying that I can't get damages through 1983
Yeah.
that actually has some foundation in our American jurisprudence?
Well, theoretically, you could have, at the time that the prosecution was ongoing, you could have filed a 1983 claim for damages. Now, without getting too nerdy about it, what would have happened is that would have been stayed while you were tried. And then you would also have brought, like, in this case, the First Amendment as an affirmative defense to your conviction. And had you prevailed, then your 1983 claim for damages would have kicked in. Then you could have actually brought that claim for violation of your constitutional rights. But it's sort of a use it or lose it sort of situation. And what you can't do is, after the fact, use the federal court system and use a civil enforcement statute to collaterally attack a conviction that you weren't able to overturn in the state court there, if that makes sense.
Yeah, which I think Clayton mentioned the term res judicata earlier. Clayton, will you explain kind of for the non-lawyers in the room, what do you mean by res judicata in this particular context?
Well, res judicata just basically means fact has been adjudicated, I think, or the matter has been resolved. Actually, fun fact, I remember this, comes from a case from like the 1200s where a guy gets his skull like bludgeoned out, and he comes and the matter is decided, and he comes back after there's more damage to his skull from the same incident, and they say, no, you don't get more damages or you don't get more remedies because this has already been decided. So yeah, basically it's just a general principle of law that says once a court has decided the matter, you don't get like two bites at the apple. And so the Heck bar effectively operates as it's almost like, major questions a little bit, like if 1983 were going to obviate that really basic principle of law called res judicata, then it would have needed to say so. So they're not going to read that into the statute.
In the context of what's been adjudicated, we're talking about the constitutionality of the statute. By pleading guilty to the statute, you are letting the court adjudicate the constitutionality of the statute, right? By making that appellate waiver, like we talked about last week. Yeah. You're saying this has been established. The constitutionality of this is something that I'm assenting to. So by coming back after the fact, you have a res judicata problem if you're going to say, actually,
you were wrong.
I
was wrong to plead guilty.
Yes, I shouldn't have pled guilty.
Yeah.
So it kind of becomes a buyer beware situation with respect to pleading guilty to this kind of offense. I think probably this is the biggest issue in the context of city ordinances, right? Because this is often going to be something that's handled at the municipal level, usually fine only. If there's a probation, it's a very brief probation. And people are going to say, well, I don't want to rack up the court costs challenging the constitutionality of this. I'd rather just plead guilty, and then we'll deal with whether I'm prosecuted under this again later on.
Yeah, and that's one of the things that's exciting about this case, where I think they really got it right. They were looking at standing in 1983 in a very practical sense. Because there you have someone that may have paid the $200 fine and then said, but that doesn't mean I want to waive my constitutional rights forever. That doesn't mean I want to just give up my ability to ever challenge this unconstitutional ordinance. As a matter of fact, now I feel like I really have standing to challenge it. It's very clear that there's a reasonable threat of prosecution because I have, in fact, been prosecuted, just like the plaintiff in Woolley versus Maynard. This has happened to me, and now I want, going forward, to be able to challenge this, not reaching back and trying to undo the fine, but going forward, I want to be able to challenge the constitutionality. I don't think most people, whenever they agree to pay that $200 fine to the city or whatever, think that they're waiving their constitutional rights forever. So I think the court got it right here.
And I think there's an interesting observation that the court makes with respect to that, of saying, if someone, we'll call him Lawrence, they call him Lawrence, if Mr. Lawrence was to challenge this statute and prevail in a 1983 action, and the same exact city ordinance is to be held unconstitutional, theoretically, if we're going to read Heck the way that the city wants us to read Heck, that statute or that 1983 action would not be available, because it does necessarily imply the invalidity of Mr. Olivier's conviction. So we have a situation created where it doesn't even matter that because Mr. Olivier was convicted under it, doesn't even matter that somebody else would have brought the lawsuit if you read the statute the way the city wants us to read the statute.
Yeah, and that's because in Heck, what the court was talking about, even though they used broad language that was then, I think, abused later by government, is they're saying, are you procedurally attacking your previous conviction? And if so, we're not going to let you do that. The language was broader, but that was the heart of what Heck was talking about. The question wasn't, are you making arguments or making that will undermine the respect for a previous judgment? It's, is the procedural vehicle you're using an actual attack on the conviction.
Yeah, because otherwise you would just like never be able to challenge the constitutionality of a law. It's like, no, there's been a conviction of this in the past, so therefore it's permanently constitutional.
Yeah.
No.
And without going,
And I think a lawyer for Olivier made a really good point in oral argument, and she said that the purpose of Heck is to protect the individual criminal conviction. It's not to protect the criminal law in the abstract. It's not supposed to insulate criminal law from constitutional challenges. It's only supposed to protect the consequences of that individual's conviction.
And they narrowed Heck very considerably to this place of saying it is the only kinds of claims that are barred are those for people in custody and for those seeking monetary damages. But is that sufficient? We talked just a minute ago about extra textual bars that judges have imposed on 1983. Is Heck rightly decided? Was this upholding of Heck, albeit by tailoring it down, appropriate?
I mean, yeah, it makes sense. You're protecting the like judicial proceeding that happened before and not upsetting it, but you are allowing litigation to proceed in the normal way that it does in this country, where constitutional questions are answered and you're not like stymieing that process. I think Heck like stays true to the meaning of 1983, and Olivier stays even truer by cabining Heck to Heck's facts.
This is also a classic case of where the outcome in a particular case made sense. If you look at the facts of Heck was bringing essentially a malicious prosecution claim, saying that the government made mistakes and made some errors that violated my constitutional rights, and so therefore I'm entitled to damages. And so the court said no, because you are necessarily implying the invalidity of your conviction, because malicious prosecution, one of the elements, requires you to show that your conviction or the prosecution itself was invalid. And so that's where this very broad language came from that said we can't use Section 1983 to imply the invalidity of the conviction. It was not what Heck became, which was a way to stop litigants from getting prospective relief from violating a statute that they had already been convicted of.
Yeah, and I think that's a really important way in which Olivier has like a really broad, helpful ripple effect in all kinds of litigation, like that we do, for example, because it kind of prevents the government from using broad language in a case like Heck to mean something that it doesn't really mean, and to prevent litigants from getting their day in court. So, like for example, so the language of Heck was very broad. It says, when a state prisoner seeks damages in a 1983 suit, the district court must consider whether a judgment in favor of the plaintiff would necessarily imply the invalidity of his conviction or sentence. But the court here is saying, no, you can't just like take those words out of context, those really general words out of context, and apply them wherever you want. They only apply to the situation in which they applied in Heck. And so they used they quoted this other case called Turkey Halk Bankasai, and
however it's pronounced.
Please correct me if I'm wrong. And that said, general languages in judicial opinions should be read as referring in context to circumstances similar to the circumstances then before the court, and not referring to quite different circumstances that the court was not then considering. So that's just a general like prophylactic language that the court and Olivier is using against state governments that will from trying to expand precedents in a way that they weren't meant to, and that helps us as public interest litigators in everything we do, I think.
I think there's an important procedural lesson here about how we read opinions generally, that we, especially because all of us in our brains are still law students, like we've still got that little law student mentality of the language of an opinion is what's controlling, but it's not. It's the holding of the opinion that's controlling.
Yeah. What happened and how do they rule on that set of facts.
Right. We're not, an opinion is not a statute. We're not reading this and saying every word needs to be given its due meaning. And I think Heck is a great illustration of that. If we took that language very literally, we would end up in a very, very, very bad place. But because of Olivier and because of the clarification of Olivier, I think there's some very helpful hints toward how we actually should read broad language like that in the future. Any further thoughts on Olivier before we move on to Mr. Foreman, Mr. Afroman? All right, so
is that his real name? Is he? I'm sorry. Go ahead.
His name is Foreman. Yeah, I think
Foreman,
I think it's Joseph Foreman.
Okay.
So the case Cooley v. Foreman has taken the world by storm. I think everyone and their mother is just referring to it as the Afroman trial. And if you are one of the 9 people in America that is not tracking this case today, Chance, will you give us kind of just the background and what happened here?
So for those of you who are not of a certain age and don't remember, Afroman was a rapper. He is a rapper. He still tours. Most famous in the early 2000s for a song called Because I Got High, talking about the struggles with marijuana use.
Mm-hmm.
And
the struggles.
Yes. And he's sort of a joke rapper. That's what his whole shtick was. And a few years ago, his house was raided by the local sheriff's department. And he had surveillance cameras in his house. So he had video footage of them breaking into his house, kicking in his door, breaking down his gate, and searching his suits and his CDs and everything else for narcotics and kidnapping victims, of which they found none. and so he made absolute bangers of singles like "Will You Help Me Repair My Gate?" and "Will You Help me repair my door?"
All to the classic tune of "But Then I Got High."
Yeah.
With the same artistic value.
And so the police officers who were involved in these videos and involved in these songs and these singles that he released sued him for defamation. And after an extended trial, Afroman won. And so what do we want to talk about?
America won.
Well, let's start with some of the details of this, because the details are funny and kind of sad. But one of the elements of the "Will You Help Me Repair My Door" is this pound cake. This lemon pound cake,
Yeah.
That there's footage of a police officer, I don't want to insult this poor man any more than he's been insulted, but a somewhat portly deputy walks past this lemon pound cake and does a double take. And so this lemon pound cake has become kind of emblematic of the suit itself, and some harassing behavior. I'm not going to say harassment because that carries legal connotations, but some harassing behavior was aimed at the sheriff's deputy. Many lemon pound cakes.
They sent him like 100 lemon pound. People started sending lemon pound cakes to the sheriff's department.
There's a separate song for that one.
There's
a lemon pound
He
cake
has a separate
song
single. Yeah,
that went viral.
To the same tune, more or less.
No, they're all different tunes.
Slightly.
To those true connoisseurs of music, they're all different.
Yes. So there's that aspect of it. There's kind of this silly, teasing, I would say lighthearted side of this. And then also during the pendency of this trial and wrapped into all of these issues is some posting that he's doing on social media, that Afroman is doing on social media, calling these people out by their names, making allegations about them. Maybe not. Allegations is a little strong. He's just asking questions, if you will. This officer's brother is a pedophile. Is he a pedophile too? I don't know. That kind of behavior that is ongoing in the background at the same time. So that's also part of the suit, but it seems like the real focus of this lawsuit is more of this teasing kind of the songs that he put out and things that he says in the songs, like he addresses one of the officers and says, "I'm having sex with your wife," that kind of teasing language. There is one sort of teasing thing that he says that actually has some pretty important implications, which is he accuses the officers of taking $400 from him, which ended up becoming a pretty important fact at trial. Do you want to talk about that a little bit, Chance?
Yeah, well, it's interesting because they are on video taking money out of one of his suits, and there was a situation where the amount of money on the evidence bag ends up being more than the amount of money that he gets back. So there is a discrepancy. The money goes into the police department, and then on the evidence bag it says this much money was taken, and then the money he gets back is like $400 less than that. And so they accuse him of defamation for claiming that money was stolen. But his argument is, well, what happened to it then?
It's not defamation if it's true.
It's not defamation if it's true. And really, a lot of this stuff, what makes it such a fascinating case, aside from the fact that the guy shows up in court in a full American flag suit, is a really interesting question about what you can say to criticize government officials that may have wronged you. I mean, do you have under the First Amendment the right to insult police officers or to insult government officials. And what the court concludes, and ultimately what this case shows, is to a certain degree, yes, you do in fact.
Not the court this time. This is the jury.
Yeah,
the jury concludes.
The jury concludes, and what the American people almost uniformly have concluded over the following weeks is, yes, you can insult government officials. In fact, there's a great tradition in America of insulting government officials that runs back all the way back to, John Adams and Thomas Jefferson, who said some really nasty things about one another during the campaign. So,
and they were even, I guess, they could be construed as false representations of fact. Even then.
Yeah.
But if they're not to be understood as being true and they're just insults, then that's not a representation of fact.
So I guess there's two questions, and I'm going to start with the broad one and move to the narrow one. The first kind of broad question, Clayton, was this a frivolous lawsuit? Like, would you say this was just brought for the purposes of quelling Afroman's free speech?
Well, I mean, in a certain sense, it does. I mean, if you watch like the first video, what's it called?
Will you help me repair my door? Yeah.
You might not think that, because that's just, or you would think that it was a frivolous challenge, because it was just a video of them going through, like, these are true factual, like, representations. It's a video of their actual conduct, and he's just kind of like making jokes as commentary to that. So to the extent that that's what the case is about, I would say, yeah, there's some frivolity there. But when factual allegations are actually made, that might not have been true.
Like, for example, stealing money from me.
Yeah.
Because we're in a different kind of class of error there.
Right.
Yeah.
So I think it depends. It depends on the standard of frivolity. Like there's these things called anti-SLAPP statutes, which we don't have to get in, but they have different. They're drafted differently depending on the state, and so the level of like frivolity that's necessary to for these motions to succeed is probably different.
Yeah.
It's certainly vibed like.
It seems like it.
It vibed like they did this to punish him for
hurting their feelings,
critiquing a government action.
Yeah.
Because they didn't find anything whenever they searched the house. There were no kidnapping victims inside his CDs, as the lyrics of the song point
It's
out.
not that there were no narcotics, but there weren't enough narcotics to be evidence of trafficking.
Right.
Or, well, I don't know. It depends. I guess you would know that, but there wasn't enough to actually.
They didn't charge him, regardless of whether or not there was enough. They didn't charge him with trafficking. They didn't charge him with anything. And I think that kind of leads to an interesting kind of question, like, if this case had unfolded exactly the same way, except they had found a woman chained in his basement, would this have gone the same way? Do you think that the jury would have still ruled entirely in favor of Afroman?
So, unlike you, I haven't argued a bunch of jury trials. So you might be able to speak to the way that things would vibe in front of the jury. But it may have. I mean, I think, so much of, and we've talked about this before, so much of constitutional law, though, really is, villains versus villains. It's not always the best person who is the beneficiary of constitutional rights.
You're not calling American hero Afroman.
No, I'm not.
He's not. To be clear, there was no woman in his basement. This is a hypothetical for purposes of education.
Or in his suit pockets.
Or in his suit pockets. Or in his CD case.
And so, whether or not he had a First Amendment right to criticize and make videos criticizing the people that searched his home would be a separate question.
Right.
Than whether or not he had ultimately been convicted. I think the biggest difference is he wouldn't have been making music videos if there had been a woman in his basement. He would be in jail, right?
Hopefully.
And that's an important thing to separate here. The question before the court wasn't whether or not the search was lawful.
Right.
The question before the court was whether or not he had defamed them by showing videos of them, at one point disconnecting his video cameras, making fun of them, if that was defamation. Yeah, breaking his door. If that's defamation, or whether or not he has a First Amendment right to be able to say those things. It's where the defamation runs into First Amendment law. And so that's what made the case interesting. I mean, had he had actually had kidnapping victims, he'd be in prison.
Right. It'd be a very, very different trial that we'd be talking about.
The songs would be less funny.
It would not
and
ring.
The jury would feel a lot less comfortable. The
officer would have been far less interested in the lemon pound cake if there had been.
Don't pay attention to this person, captured. Just, say whether the video is funny or not.
So, Eric, let me loop you in on this one. do you think that if Afroman had lost this suit, would we have a First Amendment issue? Do you think that this jury verdict would have survived if he had lost? Would this jury verdict have survived the scrutiny of the Supreme Court?
Yeah, I think the First Amendment is implicated because ultimately the question is, how far can you go when you criticize, make fun of, parody government officials? And a lot of what the First Amendment test comes down to is things being in the public interest and things being, we're trying to ensure that we are not shutting down legitimate criticism of the government, even if it's made in a funny way or in a parody way. We don't want to give the government the power to shut down criticism against it. And so there are some lines on the very outer ends of the First Amendment. If he had been calling for violence against these officers, then that could potentially, depending on the words he used, not be protected by the First Amendment. But simply criticizing or making fun of government officials is sort of in the core of what the First Amendment is all about. Now, not to get too deep in the weeds, but it would be interesting to see if he could have actually attacked that on appeal. As Chance was saying at the outset, a lot of what constitutional law is arguing about procedural matters and whether you get to make certain arguments, whether you get to stay in court. And I don't believe that he brought a motion to dismiss or any type of a defense on the First Amendment. And so it would be interesting to see on appeal, if he had been convicted, whether any claims or any defenses under the First Amendment may have been forfeited. But the good people of the jury pool found him not guilty or not
Adams
liable,
County,
I guess,
not
in this
liable.
situation. Exactly. And so, unfortunately, those fun issues of constitutional law will have to wait for the next time that Afroman makes a music video.
So we've got just a few minutes left, and I want to take some time to just examine the contours a little bit of this First Amendment right to attack an officer in their individual capacity, right? We all know that it is protected to say, this thing that this Adams County deputy did in his official capacity was reprehensible and it was terrible and he should not have done it. But when the camera pans to the person themselves, at what point do we say, yes, that individual is, you chose to be a government official, you chose to be an Adams County sheriff, so therefore, I'm sorry, you're going to get told sometimes that you have a small penis, or you're going to get told sometimes that you smell funny, or whatever. At what point do we say, no, actually you've crossed a line and you can't attack this person in their individual capacity anymore because that has become true dyed-in-the-wool defamation? Or is our position as an organization, or I suppose as the four of us at this table, that at any point in time an officer can be criticized in any way, personal or impersonal, true or false, because they are agents of the government?
I mean, we're not defamation experts. I think that's
true.
important.
That is important to point out. We don't do this for a living.
And because it's a tort, it's different in every state.
Yes.
Too. So we're certainly not Ohio defamation experts.
Well, the question I'm asking is a constitutional question.
So generally, I think that where the breakdown is, are you making a false statement of material fact? Are you saying, hey, I saw this guy murder 3 people, and you know that's false? Well, then, maybe the First Amendment doesn't reach that or protect that. But if you're saying, I think this guy's a coward, I think this guy's any number of things, and that like most things in law, it's going to turn so much on context and so much on the facts and so much of, what a reasonable person is going to believe under that set of facts. Mm-hmm. And so there's that meme. Y'all know that meme where it's like, there's the building that's tipping over and it's being held up by a stick. Mm-hmm. And it says the entirety of the American judicial system. And the stick says the reasonable man standard. Like all of jurisprudence is held up by this. Like, what would a reasonable observer think you're doing? Are you doing parody? Are you making a joke? Are you giving an insult? Or would a reasonable person think you're making an actual allegation that this person's committed some sort of separate crime? And I think that's where the difference is going to be.
Are we looking at a reasonable person of today, or are we looking at a reasonable person of 1790? Are we looking at the reasonable person, what we would find as not protected today, or are we looking at what the founders would have found as not protected once upon a time?
I'm not sure that it changes one way or the other. I think what you're really looking at is what a reasonable person would think this person is saying. are they making a statement of fact that this other person has engaged in some sort of crime or did some sort of nefarious deed? And that's going to be the same regardless.
Yeah, I think like since 1790, the context has always been a relevant part of that analysis.
Yeah.
And so the context is always going to be present. Like, what does a reasonable person who heard it think?
So we're not necessarily going to use Jefferson calling Adams a hermaphrodite as a barometer for the constitutionality of a given speech.
Well, what's interesting about that particular statement is I think it was someone that Jefferson allegedly paid to be his hatchet man, and this person said that Adams was hermaphroditic.
Oh, okay.
Yeah,
not quite.
Had neither the qualities of a man or a woman is what he argued, and so this was an attack on Adams' character, right? And I think to put that into perspective,
more of an opinion.
It was an opinion about Adams' character, calling him a hermaphrodite, rather than his actual anatomy in some sense. But again, these are the sorts of things that you would have to argue about.
But there is a higher standard, and maybe this is what you were getting at earlier. If you're a public official. It's not just that it has to be false, but the official who's suing for defamation has to also prove that the speaker had actual malice, which means that they knew what they were saying is false. So you can actually say something false about a public official, but if you didn't know and it was kind of just like your mistake, that actually is still protected by the First Amendment.
I think we will probably, I assume, at some point get into the whole New York Times standard of actual malice and all of that. But to avoid getting into that today, just one more general question. How do we feel about the public response to this? Good, bad, indifferent?
I think it's kind of awesome that, and despite how polarized that we are at this point, I think everyone in America
unite behind
was all excited.
Who had that on their bingo card for 2026?
Everyone seems to love this, early 2000s rapper now that he stuck it to the government, right?
Yeah, I think it's very healthy.
I think it's very American. This is it. We don't really care what you're saying, and I'm sure that everyone would find at least some degree of what he said a little bit reprehensible. But at the same time, we are also excited that his right to say it has been vindicated. I think that's
at his trial,
what separates us.
Sorry? And at his trial, he's literally clothed himself with the American flag. It doesn't
literally wearing American flags.
Yes,
I want to know what judge let him get on the stand in sunglasses. I don't think I've appeared in front of a single judge that would have let a witness get on the stand in sunglasses, but he did, and they were fabulous, absolutely fabulous. So there's hope for the First Amendment yet. There's hope for our country yet. I think that brings us to the end of today's docket. Thank you all so much for joining us. If you've enjoyed our conversation today, leave us a review and join us next time for more Rightly Decided.